quite a crowd in here. Hopefully we're not violating the fire marshal's laws. I know the overflow room is also full. Welcome back to our conference, International Law in Crisis. It is my extreme pleasure to introduce to you today's luncheon speaker. I think many of you came to this conference because you were interested in what he has to say. We have a record crowd at this conference. We had 190 pre-registered people, which is way more than we usually get. And we also have probably about 1,000 people watching us live, and another 10,000 will watch it archived. Let me start by telling you about Richard Goldstone's career and then about his special relationship with this institution as part of my introduction. Richard Goldstone was a pioneer in fighting apartheid. And the Goldstone Commission, the first commission that bears his name, was one of the most important institutions that helped dismantle apartheid in South Africa. When the Yugoslavia Tribunal was formed, and I was working at the State Department as attorney advisor for UN Affairs, they were struggling to find somebody that could be acceptable to the whole international community, to be the first prosecutor of an international tribunal since Nuremberg. It took them 14 months and dozens of candidates before they all settled on a consensus on Justice Richard Goldstone. At the time, Richard had just been appointed to the Constitutional Court, which is like our Supreme Court. And so he had to ask for a leave of absence, which Nelson Mandela gladly gave him. I'm sure there was some tough negotiations. But it was similar to when Robert Jackson took a leave of absence from our Supreme Court to be the first prosecutor of the Nuremberg Tribunal. When Richard created the Yugoslavia Tribunal, and I use that word intentionally because he was the founding father, he was the one who took a tribunal that most people thought was just put together as a Band-Aid or just some kind of a propaganda tool to show that the West was doing something when it refused to put ground forces or air forces to stop the atrocities in Bosnia. Nobody really thought it was going to succeed. Nobody thought that the top 10 people that Eagleburger had identified as the worst culprits would ever see justice. And yet over the years, especially because of the dint of Richard Goldstone's personality and his politics and his fundraising and everything he did to create this little institution and turn it into a huge tribunal that it dwarfed Nuremberg, they got Milosevic, the leader of Serbia. They got Mladic, the main general. They got Karadzic. In fact, of all the indictees, every single one has now been arrested, brought to justice in The Hague. Nobody would have thought that would happen, and that's because of Richard Goldstone. Now, when Richard left the tribunal back onto the Constitutional Court, he took on a series of other important work. He worked on the issue of Kosovo's status, and he worked, of course, as the Dean mentioned this morning, on the very controversial Goldstone Commission report. For the law school, however, he has played also a very special role. I met Richard 19 years ago at a conference in Syracuse, Sicily, and we established what became a very active academic consortium that is based and headquartered here at Case Western Reserve, where we do work for all of the international tribunals. We started working for the Yugoslavia Tribunal. When it expanded to the Rwanda Tribunal, we also expanded. When Dave Crane became the chief prosecutor of the Special Court for Sierra Leone, Richard suggested you might want to have Professor Scharf and his students help you out as well. So we took on that. Same thing with the Cambodia Tribunal and the Special Tribunal for Lebanon. In addition, one of our favorite alumni, who's profiled in the upcoming In Brief, which is our alumni magazine, Chris Rossi, started his career as Justice Goldstone's law clerk at the Constitutional Court in South Africa, as did an alumni, or as did both an alumni and a colleague that's now down at Cleveland State, who also has invited Richard to speak there this afternoon. And he will be. After he leaves here, Cleveland gets a double dose of Richard. Now, from the tribunal work we did, we ultimately, together with the Public International Law and Policy Group, our program doing this work for tribunals was nominated for a Nobel Peace Prize. And it's brought a lot of good attention to the work we do. It also has really helped build up this program. Now, over the years, Richard has also come, no matter how busy he was, and spoken at our conferences. He's been the Klatsky Endowed Lecture, which is a human rights lecture. He has spoken at major conferences we've had. 3 years ago, maybe it's 4 now, he was selected to get the honorary degree from this university. So he is an alumni of this university. And we're proud of him, no matter how controversial some people think his report is. I will say this, as the dean suggested, we love controversy here because that's what an academic institution does. So last year we had a program that unfortunately Richard was not able to come to, where we debated for hours the Goldstone Commission report, and several of the panelists here have written articles, and these were available still, are available out in the hall. If you want to see the dissection of every dotted I and T and everything in the Goldstone Commission report, we did that. So we don't shy away from critique here. But we didn't invite him today to talk about the Goldstone report. Lots of stuff are going on in the world about international law and crisis. We've got Gaddafi on the run. We've got al-Bashir, who's been indicted by the ICC. We have lots of major international criminals that need to be brought to justice. And there's nobody in the world who knows that topic better than Richard Goldstone. So we asked him to come here and talk about that. So his speech today will be about that. He'd like his questions and answers to be on that subject. After this, there's going to be another panel about the Middle Eastern crisis. And if we want to go back to talking about the Goldstone report, we can do that in that panel. But for this panel, we're focusing on this expertise that Richard Goldstone brings that nobody else really has in the world, and we're so happy to have him here. Please join me in welcoming Richard Goldstone.
Well, Michael, thank you very much for your very warm introduction. It's a great pleasure and privilege to be back at Case Western. I've made a number of visits here and spoken at similar seminars and other functions to which Michael has referred, and I've had a very warm relationship with Michael for all these almost two decades in which we've worked together in many areas of international humanitarian law. I hope too many of you won't be disappointed if I'm not going to talk about fact-finding missions. I don't believe that they're directly relevant to the issue of international law in crisis. And let me say only this, that the view I've just expressed is based on the fact that fact-finding missions are not judicial, they're not quasi-judicial, they don't make the law. They provide, or may not provide, as the case may be, factual background and possibly even legal views which are not binding on anybody, but may find them, may or may not be useful to political bodies or to legal bodies out there. We heard an excellent introduction to this conference yesterday evening at, of all places, the Rock and Roll Hall of Fame. I must say I didn't envy David Crane talking in that atmosphere, but he overcame problems that I would have thought were impossible to overcome, and it was a very sober, somewhat pessimistic introduction to the topic, and I think he was wise to set that tone for a conference that is on the crisis, called the crisis of international law. I'm more optimistic. I don't believe I'm a starry-eyed optimist, but I am an optimist, and my optimism led me to decide to talk not about the crisis of international law, but rather the crisis in the implementation of international law. International law really, save in some respects, and I learned one respect just before lunch at the excellent panel on climate change. I think there's an area where there is a crisis of a different nature, and I'll come back to that at the end. I think all of you, like me, were frustrated at not being able to attend all of today's panels because they've all been excellent, and warm congratulations to Michael and his colleagues on the organization of yet another outstanding conference with a gathering of outstanding people who could talk to the various topics that we've been feasted on today. International law, far from being in crisis, is in fact being relied upon and called in aid more and more by international leaders than ever before. The role of international law could never have been anticipated but a few years ago. The question, as I've already indicated, that we have to ask ourselves is whether international law can fulfill the expectations of those relying upon it. And let me say too, by word of warning, that too many people place too much of a load on the law. The law is but one tool, and in many respects an insignificant tool, in the development of peace and security and economic sustainability. The law is a tool in that regard, but without the political will, without the economic resources, it cannot be a magic wand that is going to cure the most serious problems that the world community is facing. Let me do two things. Firstly, point out the huge developments in various areas of international law, and secondly, when I've done that, to talk about the implementation. And let me start with the area that I know best and to which Michael has referred, and that is international criminal law, and in particular the International Criminal Court. When the International Criminal Court was agreed to in Rome in the middle of 1998, this huge threshold of 60 ratifications before the court could begin was seen by the majority of optimistic people as a huge threshold that would take at least a decade to reach. But as we know, it took less than 4 years, and amazingly today, 117 of the 193 members of the United Nations have ratified the Rome Treaty. It's interesting looking at the 117 nations by region, by UN region. Africa, 32. Latin America and the Caribbean, 26. Asia and the Pacific Islands, 16. And Europe and the CIS countries, 43. It's a huge, huge development, and it includes the 43 from Europe include every member of the European Union. It is possible that the so-called Arab Spring might bring more Arab countries into the ICC fold, and there's been an unfortunate shortage of Arab countries who have ratified the Rome Treaty, and for reasons that speak for themselves. So far, Tunisia has come out of this Arab Spring and has now ratified the Rome Treaty. Others may follow, and certainly depending obviously entirely on developments in those countries and whether democracy in fact will come to them. Because it's democratic nations more than others that accede to the Rome Treaty and are prepared to make themselves parties to international humanitarian law efforts. Then there's the use of the ICC by governments. It's a strange irony that African countries, 3 of them, have in fact approached the ICC and said, please come and investigate what's happening with regard to war crimes in our country. The first 3 cases before the ICC, from Uganda, from the Central African Republic and the Democratic Republic of the Congo, came from governments. Again, nobody anticipated at all in 1998 or 2002 when the court began, nobody anticipated that cases would come from governments. It was assumed that all the cases would be initiated by the prosecutor using his own what are called propria motu powers, his powers of referring cases for confirmation to a pre-trial chamber of the International Criminal Court. So 3 came from African governments. Of the remaining 3 before the court, 2 came, again, to the amazement of the most optimistic supporters, from the Security Council. It was assumed that the Security Council, for the foreseeable decades, would never refer cases to the International Criminal Court because of the United States veto, and the Russian veto, and the Chinese veto. Powerful countries don't like international courts. Powerful countries don't like international adjudication at all. Powerful countries don't like people from other nations looking over their shoulders and giving judgment on what they are doing. 2 cases from the Security Council, and 1 during the second term of President George W. Bush. In his first term, he went to extreme lengths to try and kill this court in its infancy, to the extent of getting Congress, a compliant Congress, to pass what then seemed and seems even more today as ridiculous legislation, the Hague Invasion Act, which would authorize American troops to go and rescue poor Americans who might be brought before the court in The Hague. It really beggars the imagination that the Congress of the United States could even consider, let alone pass legislation of that nature. John Bolton saying the happiest day of his career was when he informed the Secretary General that the United States was withdrawing its signature from the Rome Treaty. It was that administration in its second term that decided not to veto the reference of the Sudan, of the Darfur situation, to the International Criminal Court. So one never knows, and certainly the odds on that happening were just about zero weeks before it happened. 2 weeks before the United States announced it would not veto, the then ambassador for war crimes in the Bush administration, Pierre Richard Prosper, who incidentally used to work for me in the Rwanda Tribunal, Ambassador Prosper said, we will veto the reference because a reference by the Security Council will give the International Criminal Court credibility. He was right. It did give it credibility, but he was wrong with regard to his statement that the US would veto. And who would have believed that as recently as this year, the United States would vote affirmatively? The Obama administration voted affirmatively to refer the Libyan situation to the ICC, which has resulted, as we know, in the indictment of 3 Libyan leaders, including Gaddafi, as well as one of his sons and his security chief. So there is reason for optimism in a situation where pessimism had really overtaken the events and the prophecies that people were making with good rational reason. I might say, in parenthesis, that I questioned the timing of the reference of the Libyan situation to the ICC. The fact that the Security Council used, for the first time, the responsibility to protect, because that's what it was, in authorizing NATO powers to assist the rebels fighting against the regime of Muammar Gaddafi. The reference to the ICC seemed to me to be premature. I'm happy that my concerns have proven to be ill-founded. The fighting is coming to an optimistic end with the end of the Gaddafi regime. What will come in its place, we have to wait and see. If there's some form of democratic government, if decent operating courts of law can be set up, even one and possibly with international assistance, I certainly would strongly support a trial of Gaddafi in Libya, subject to his being able to be given a fair trial by acceptable international standards. A big if. I think that the Libyans have a long way to go in forming a government at all, let alone a democratic government. But if they can do that, then complementarity, on which the International Court is based, would favor a trial in Tripoli or somewhere in Libya rather than in The Hague. I'm not optimistic that that will happen, and if it doesn't, then of course the International Criminal Court must insist on the arrest warrant being carried out, and Gaddafi, if he is arrested, being tried in The Hague. The most unusual resort to a quasi-international court, we've had the Special Court for Sierra Leone, on which David Crane has often very spoken with pride, very justifiable pride, because of his efforts as the first Chief Prosecutor, and its many successes are due to his imaginative use of the powers that were invested in him. But the second or the third or the fourth a hybrid, so-called hybrid or mixed tribunal, that for Lebanon, the jury is still out. But here was an amazing reliance on international law, setting up a mixed court, sitting in The Hague for Lebanon, but investigating, in effect, one murder. I think many people question the rationality or the good political sense which led to that, and I think there too the jury is out. It seems unlikely in the extreme that the people who've been indicted will ever be brought to that court, and the intention, as I understand it, and it's possible under the statute under which that court operates, that there will be a trial in absentia. And I certainly, for one, don't like trials in absentia. I believe they bring cold comfort to the victims, and from a prosecutor's point of view, I think they poison. Because if the accused person is ever brought to court, the trial in absentia is rendered as if it didn't exist, pro non scripto, and defense counsel have a wonderful opportunity of cross-examining major witnesses who've already given evidence in the trial in absentia. Another problem, incidentally, with trials in absentia is it makes important witnesses marked people for assassination. And that's another huge danger of trials in absentia. But you can see the tremendous reliance on international criminal law. And international law, as I've indicated, has been called upon more and more rather than the contrary. Let me move away from criminal justice and look at a couple of other areas of international law and decide whether they're in crisis. The International Court of Justice, the so-called World Court. When I was in The Hague in the middle 1990s, that court was almost ignored. I remember they had about one or two cases a year. And I remember my amusement when I met with some of those judges of the International Court of Justice who complained that they were overworked. It was really Parkinson's law. They worked harder on 2 cases than they would have on 200 cases because they had nothing else to do. That has changed considerably. The International Court of Justice presently has 18 cases actively going on in front of those judges. And that indicates, and what's important, is only governments can litigate in front of the International Court of Justice. No individuals, no organizations, only governments, and they can't be forced to. They go there willingly because they want to have their dispute settled by the International Court of Justice. So there's been a huge proliferation, relatively speaking, of cases before the International Court of Justice, and these are brought by governments. The World Trade Organization Appellate Body is a good example of the huge increase in the use by governments of international law. Until 16 years ago, trade disputes between members of the World Trade Organization were settled by quasi-diplomatic proceedings between governments. The system was directed not at litigating differences, the system was directed at finding solutions, and frequently by way of compromise. It was usually diplomats who argued the cases in that court, not lawyers. Today, the WTO dispute settlement system is really based on the rule of law. There are now binding outcomes and a final court of appeal, the appellate body of the WTO, sitting in Geneva. And again, by way of a footnote, the reason it's called the appellate body, I understand on good authority, was to satisfy the United States and make it comfortable for the United States to join an appellate court that wasn't called a court. So they called it the appellate body to make it palatable in Washington, D.C. Doesn't matter, it works. The present chairman of that court is an American, Jennifer Hillman. She has said, and I quote in a yet unpublished piece, she said, the parlance of disputes has shifted from one of compromise and settlement to one of winners and losers, victories and defeat. A substantial number of precedents have grown up in that court, They are persuasive rather than binding authority. It's interesting to see the countries that use that appellate body of the WTO. And we're talking about billions and billions of dollars involved in the cases that come before it. The major user has been the United States. Figures relevant at not more than 6 months ago. The United States has initiated 93 cases before the appellate body and has defended over 100. The European Union initiated 82, defended 86. Canada initiated 33, defended 15. They're followed by Brazil and India, Mexico, Argentina, Korea, Japan, and Thailand. All those countries significant users of the appellate body of the WTO. What to me is the most significant development is the use being made in recent years of the WTO appellate body by China. First in defending cases, and now more and more frequently as an initiator of complaints before that body. Finally, with regard to that body, what is also significant is that in the overwhelming number of cases it has heard, according to Jennifer Hillman, the WTO requirements have been found to have been substantially violated, and orders of compliance were issued by the appellate body. In almost every case, the United States, China, India, you name them, the countries have carried out the orders and the decisions of the appellate body of the WTO. Turning to the European Court of Human Rights, it's being used out of existence. It's got a backlog, apparently, of well over 10,000 cases and growing, many of them coming from Russia who submitted to the jurisdiction of that court. So one sees in these areas, and there are others, that there is an increasing reliance on international criminal law. So far from being in crisis, it's being used more and more and being called in aid more and more. But let's turn to the area where I would suggest there is crisis, and that is in the ability of most of those courts to satisfy the calls that are being made on them. Let me go through the ones I've referred to. I needn't refer to the WTO because one sees there that it's being used and it's coping. It's coping well. What of the criminal courts, though? The ad hoc tribunals are winding down. The Sierra Leone tribunal is winding down. The Cambodia tribunal hasn't got too much life left in it. East Timor has already gone. And as David Crane indicated last night, in a very few years from now, the only international criminal court will be the permanent ICC. And David, with every good reason, was bemoaning the fact that with that court as the only court, the United States influence will have become diminished. I suggest not to the point of extinction, because I think the United States will always play a crucial role in that court, even if it doesn't ratify the Rome Treaty. And again, let me come back to that, and I say that. Let me just anticipate this. The United States will continue to play a role because of the activities of civil society in this country. Many of the people responsible for it so far are sitting in this room, and you know who you are. And without you and without your efforts, international criminal justice wouldn't have notched up the successes that it has over the last 17, 18 years. But the ICC is facing crises. It's facing crises mainly of perception. But again, as I think David Crane indicated, perception's a fact. It's not just a theory. What people perceive is a fact. Their perceptions may be right, their perceptions may be wrong, but they have to be taken into account. The perception in Africa that the International Criminal Court is anti-African was set up by Western countries to investigate Africans. Of course, that perception exists and it's been nurtured by politicians, and sometimes I would suggest with respect dishonest politicians, because it's completely unfair for the reasons I've mentioned. Only one of the 6 cases before the International Criminal Court has been referred by the prosecutor. The other 5, as I indicated, 3 by governments, 2 by the Security Council. The court didn't choose those situations. The court was chosen to look into those situations. And the perception is going to remain until, I hope, in the coming few years, the International Criminal Court is going to become seized of situations that don't only relate to sub-Saharan Africa. So that's the one problem of perception. The second problem, of course, is the number of governments that have failed to honor their international legal obligations. No international law can be of any utility, can be of any force, unless there's a political will of the parties, of the governments, of the nations parties to them, to carry them out and to adhere to them. This is one of the, probably it's the greatest problem and weakness of international law. No international court, no international body has, or in any of our lifetimes, will ever have its own police force or its own army to go and execute its judgments. It is now and will remain completely dependent on the support and cooperation from national governments. That's a fact of life. And I read some years ago, somebody, and I've forgotten who it was, said if there's a problem with no solution, it's not a problem, it's a fact, and you have to deal with it. And the fact of international law is that it depends and will always depend on the cooperation of national governments. And that's not a problem, it's a fact, and it has to be dealt with. And of course, that's the importance of the United States, certainly until now. David knows, I know, all chief prosecutors know, past and present, that the United States played the crucial role in making these courts work. The ad hoc tribunals wouldn't have been set up without the United States support, and it was mainly Madeleine Albright who was responsible for it. Having been set up, they wouldn't have succeeded. We wouldn't have got intelligence information. We wouldn't have had sufficient staffing. We wouldn't have had sufficient money. But most important of all, the courts wouldn't have got their major culprits before them without the political and economic power of the United States and its willingness to force governments to cooperate with the court. Milosevic wouldn't have been there. Karadzic wouldn't be there now. Mladic wouldn't be there now. The leading generals, Gotovina and the others who came to the International Court, the Rwanda Tribunal succeeding, none of those things would have happened, I know, from my own experience, none of those things would have happened without the active support from Washington, D.C. So it's a problem that the International Court has. It hasn't been as fortunate as these other courts were, but that seems to be changing. And that support can be forthcoming from Washington, even if the United States does not join as an active party. Of course, any of us who support the International Criminal Court would be joyful to a huge extreme if the United States would ratify the Rome Treaty. And that's the big question out there, and that is whether the court will succeed in the coming decade and more, will succeed without the active support of the United States. Because if it doesn't, it will die, and if it does, I'm prepared to stick my neck out, and I probably won't be around to rue the day. I've no doubt eventually the United States will ratify. And I say that because the people of this country don't approve of war criminals. The people of this country don't want war criminals to have impunity. And if the United States government and if the United States President and the Senate come to the conclusion that it's in the interest of the United States to join, they'll do it. They're not going to do that unless and until, and understandably so. No legislature, no president, no head of state, no parliament is going to take a step that they believe is not in the interest of the country that they lead and represent. Let me draw this to a conclusion by referring to a recent book some of us, I'm sure some of you have read, Joseph Nye's book called The Future of Power. He convincingly distinguishes, on the one hand, between the transition of power between states, and he talks importantly of the transition of power between Asian and Western states, and particularly the rise of China and India. That's the transition of power, and the fear by many in this country and other Western countries that the United States' preeminence is on a downward curve and China and India is on an upward curve, a topic we're not going to discuss today. He opposes to this transition of power the diffusion of power between governments, from governments to non-state actors, and in particular non-governmental organizations. This diffusion has been facilitated by the cyber world in which we are living, and we see many of examples of it right now. The tent cities in Israeli cities, the Arab Spring, none of these things would have been conceivable without cyber power. The riots in London and so forth. As Nye put it, he said, in a world where borders are becoming more porous than ever before, to everything from drugs to infectious diseases to terrorism, nations must mobilize international coalitions and build institutions to address shared threats and challenges. And one current illustration of the growing relevance of NGOs, and let me give just as briefly as I can, an example, which I've discussed with a couple of you. The CICC, the Coalition for the International Criminal Court, amazing organization, the largest non-governmental organization, I guess, in the world. It's a coalition of over 2,500 NGOs from over 120 countries in one organization, and it's brilliantly led by an American, William Pace, out of his office in New York. There's been concern at some of the judges who've been nominated for the International Criminal Court over the last decade. And with the full consent of the leaders of the assemblies of states parties, the main parties running the International Criminal Court, the CICC set up a panel of 5 individuals with no international powers at all. It's an NGO. We call ourselves the Independent Panel on the Election of Candidates to the ICC. That's going on right now. The closing date has just been extended from the 2nd of September to the 16th of September. But 5 of us have been appointed from 5 regions of the UN. I was appointed to chair it. Judge Pat Wald of Washington is vice-chairing it. Hans Corell, the former Under-Secretary General for Legal Affairs from Sweden, is on it. Judge Ogon Kwan from the Yugoslavia Tribunal is on it. And Cecilia Medina from Argentina, leading Latin American judge and lawyer, is the fifth member. What will we do? All we'll do is look at all the documentation that comes to the Assembly of States Parties from governments, and we will, referring solely to the provisions in the Rome Treaty, which sets out the qualifications of judges, we will issue a public report before the election saying whether the candidates are qualified or not qualified. The idea is that this should act as a deterrent, that government shouldn't put forward candidates who are likely to be held to be unqualified. But the point I want to make is, who would have thought 5 years ago that governments represented in the Assembly of States Parties, now 117 countries, would welcome an NGO doing this work? It's really a good example, I think, of what Joe Nye calls the diffusion of power to NGOs. Of course, this diffusion carries its dangers. Al-Qaeda is also the result of this sort of diffusion. So diffusion from governments to non-governmental organizations can be for good, and it can be for evil. And so again, it's a mechanism that one must watch. Finally, I was impressed at the last panel before the luncheon adjournment on global warming. I went to that panel because I know so little about it. I thought it was a good opportunity to learn something. And it seemed to me that there is an area of international law that's in crisis because insufficient has been done about it. More law is needed, and more political will is needed in order to comply with the tremendous needs that were so articulately and very clearly pointed out by that panel. So I hope I've said sufficient to demonstrate that far from being in crisis, international law continues to be an essential tool, more and more to resolve some of the most difficult and important problems facing our global community. The issue and the problem in the main is the ability of institutions designed to implement international law from doing their job. Thank you very much.
Thank you very much for those insightful remarks. We'll now have 15 minutes of questions. Just come up to the microphones and line up behind each other. Please identify where you're from and your name, and then ask the question. And you'll just,
Hi, my name is Kevin Hartman. I'm a student here at Case. I was just going to ask you, the Security Council has referred Ali Bashir to the ICC, and consistently he's traveled to other African states without being taken to the ICC. And I was wondering, is there any law around holding the leaders who aren't bringing him to the ICC to justice, and what can be done about this in the future?
Well, of course, this is perhaps one of the most vivid examples of some of the problems that are being faced by the International Criminal Court and its reliance on governments. It's disgraceful, of course, that at least one government, which is a party to the Rome Treaty, allowing President al-Bashir under an arrest warrant to come into the country and not to arrest him. But that's the exception. As a South African, I'm proud that our government indicated to President al-Bashir that he was the only African leader not being invited to the inauguration not long ago of our President Zuma. The ambassador from the Sudan was called in and told, your president is not being invited because we would be obliged to arrest him and hand him over for trial in The Hague if he were to come in. The government of Botswana made a similar declaration, and at least one government, Kenya, cancelled after there were complaints. But this is the problem, and it's not the first time it's existed. And incidentally, the two short points about that. The arrest warrant against al-Bashir has rendered it very difficult for him to be a head of state. Heads of states have difficulty if they can't travel freely, and he can't travel freely. And that is obviously a way in which he's being marginalized to a great extent. There's no European power. He can't attend a meeting in the United States or Canada, because the United States was a party to the Security Council resolution. Although not binding, no doubt the United States would certainly want to see al-Bashir brought to trial. So this is a mixed report. But more and more countries that ignore their international obligations are going to be castigated. They're going to be isolated. Because if countries refuse to carry out their international obligations in that area, they're going to be distrusted. Governments who don't carry out their obligations are going to be suspect. And people will start worrying about doing trade with them, because if they break their word in that respect, they'll break their word in the other respect. And more governments have to comply with international law if they want to have credibility.
Thank you.
But there's nothing, to answer your question directly, there's nothing that can be done against the leaders of those countries, because it's not criminal not to carry out your obligation. It's a breach of the international treaty, but it's not a criminal offense.
Hi, my name is Nick Weiss. I'm a second-year law student here at Case, and you talked about this briefly, but the ICC has indicted Gaddafi, and the transitional government has also said that it would like to prosecute. Which of these two courts do you think should prosecute Gaddafi?
Well, I think I did refer to that briefly in my opening remarks. Certainly, my own preference. I must say, I was a late comer to support the system of complementarity. For those of you who don't know, the International Criminal Court in The Hague, the permanent court, is referred to as a court of second choice. The court that has the first right to investigate and prosecute and punish war criminals is the court of the country from where that person comes, not the International Criminal Court. It's really reversed the situation that existed with the United Nations tribunals, who had first choice. The International Criminal Court may not get involved in any criminal case if the country, if a country whose courts have jurisdiction wish to do so themselves. Take an example, if somebody from the United Kingdom, if a soldier from the United Kingdom was charged with war crimes committed in Afghanistan or Iraq, the United Kingdom could say to the International Criminal Court, we will investigate. If the United Kingdom does that and investigates in good faith, regardless of the outcome, the International Criminal Court has no jurisdiction. Principle of complementarity, putting the onus on the country of the citizenship of the alleged criminal. And there's no reason, in my view, why that shouldn't, in theory, apply in Libya. The question is that it can only happen if the local court, if the domestic court, is willing and able to hold a fair trial under international standards. And if and when Libya will have a court that can hold an open and fair trial by international standards, your guess is as good as mine. And until that is likely to happen within a foreseeable future, within a short time, it seems to me that the international court's the only court with effective jurisdiction. And if I was in the position of the chief prosecutor or the judges of that court, I would insist on the international court proceeding against Gaddafi unless and until the Libyan court, if necessary with assistance from other countries in the international community, is able to put on the trial. And let me say I favor it not only because that's what the Rome Statute provides, and it's not only because that's the basis on which the International Criminal Court applies. I say it because first prize in any justice system is that trials should take place at or as close to the scene of the crime as possible. That's where the victims are. If a criminal justice system is to have credibility, it should be at home. It's very different. One of the problems that the Yugoslavia tribunal, the Rwanda tribunal suffered is that the trials took place many thousands of miles away from where the crimes were committed. And that's a downside. There's often no alternative. But if there is an alternative, it should be grabbed.
Thank you.
Thank you. My name is Jessica Fiel. I'm a student here at Case. You mentioned it briefly in your speech, but I was wondering if you thought the criticisms of the International Court being too focused on Africa are in fact legitimate. If you could explain.
Sorry, could you speak up?
Sorry. If the criticisms of the International Court typically say that it's too focused on Africa, could you expand a bit on whether or not you think that's a legitimate criticism?
Well, as I've said, I think it's a very unfair criticism for the reason I've mentioned, and that is that the African governments can hardly complain if they themselves have been responsible. I understand the perception. The perception of the African Union, of a number of African states, it is peculiar that you have an international criminal court mainly supported by northern and western countries. The only cases before the court happen to be African. This looks like, to many people, a sort of neo-colonial, Western imperialistic decision to go against African countries. And let me say what exacerbates it is the failure to go against powerful countries. War crimes, we know, have been committed ad nauseum by Russia, by China, by other Asian countries. They're not before the International Criminal Court. They're not there because they're not prepared to join in. They're not prepared to ratify the Rome Treaty. And they've got vetoes in the Security Council. So one has to be a little bit sympathetic to the African perception. I think it's unfair, and as I say, it's going to continue to exist until non-African countries come before the International Criminal Court.
Thank you.
I'm Claude Welch from the University of Buffalo and one who's followed the role of international human rights NGOs. I wondered if you could speak to the possibility that appointing an African prosecutor might help to reduce the concerns that are expressed, the critique that you just spoke of, both in your remarks and in response to that last question.
Well, you know, the present prosecutor's term of office comes to an end in the middle of next year. And there's already a search committee being set up by the Assembly of States Parties to look for a new prosecutor. And there's a lot of talk out there, newspaper articles, rumor, that for the reason you mentioned, there should be an African prosecutor. And one of the front runners is the present deputy chief prosecutor, Fatou Bensouza, who is a black African. I have a problem with the theory that the prosecutor should come from a particular country, but having said that, as an African, if an African is, all things being equal, the best person to be the chief prosecutor, great. That's a matter for celebration. But I certainly would be against the appointment of somebody simply because of the country they come from or the color of their skin. I think the most appropriate, the best qualified person should be appointed. And if that person happens to come from an Asian country, so be it. I certainly would be strongly against appointing somebody simply because they come from a particular continent where there are other candidates with better qualification.
Thank you very much.
Hi, my name is Danielle Fritz, and I'm a law student here at Case. A few months ago, the UK foreign minister suggested that it might be a good idea to negotiate an exile for peace deal with Gaddafi. Are these agreements ever in the interest of international peace?
You know, one must distinguish, it's a great question, one must distinguish between political decisions being made with regard to international justice and courts on the one hand, and legal decisions on the other. In my view, and it's something that David Crane have often debated and not always agreed upon, in my view, the prosecutor and judges should take legal decisions. They've been appointed not to be politicians. And if they were, they'd make the lousiest politicians in the world. I've no doubt about that. They may even not be the greatest lawyers, but they'd be the worst politicians. It's not their calling, A. B, they're not parties to peace negotiations. They don't know what's going on. I agree with David that prosecutors should not have their heads in the cloud and should be aware of the effect of what they do. But in the case of Gaddafi, I've no doubt the court's job is to get him on trial for terrible crimes he's committed in the very recent past. If it can be established, and it's a very big if, that peace would come to Libya if Gaddafi was given asylum in some lovely country like Zimbabwe, that would be a question to be determined by politicians, not by lawyers. And the politicians who would have to decide that would be the Security Council. The Rome Treaty, setting up the International Criminal Court, provides that the Security Council can order proceedings in that court to be suspended for successive periods of 1 year. If there was rational evidence that could persuade a majority of the Security Council with no veto that it's in the interest of the people of Libya that Gaddafi should not be prosecuted, that would be a political decision. And frankly, I wouldn't lose any sleep if they took that decision. But it's not a decision, I believe, should be taken in The Hague by the prosecutor, or the prosecutor's got no power to make it anyway, I'm happy to say. But the judges may or may not be able to take such a decision. But they certainly wouldn't do it if the prosecutor didn't request them to do it. So I think there are very few cases where giving effective amnesty or asylum to the worst war criminal is going to bring any enduring peace to a situation. Certainly it's been the experience in the last 17 years since there have been international criminal courts that justice and prosecution have assisted rather than have assisted the police, the peace rather than the converse.
Thank you.
Last question, Ruth.
Well, I certainly agree with you that Ocampo, I think, has done a very prudent job in steering the court and giving it sea legs. I had three quick, each hard questions, so none probably admitting of yes or no answer. First, just forgive me for raising this, but I take the performance of the ad hoc tribunals as a very important precedent for the performance of the ICC, and because they really were the test runs, if you will. And I'd mentioned this morning the fact that ICTR, the Rwanda tribunal, never did try any Tutsi cases gives pause to people who want to suppose the courts can take a purely apolitical stance. Second, just a lawyer's question. On complementarity, you're supposed to be unwilling or unable to be able to handle the case yourself. Not that you'd rather not. So I'm wondering what you think. Is some defense lawyer going to have an argument that rather not is not a satisfaction of complementarity? You have to be objectively unwilling or unable, but not that you'd prefer to push it off on. For political reasons, perhaps, because it's easier to have The Hague decide it than be responsible.
Well, Uganda's a good example.
And the final one, if you answer or not as you see fit, but I'm straying a little bit here, but shouldn't perhaps the principle of complementarity also apply to political bodies? For example, the Human Rights Council is now deciding whether to take up Sri Lanka. And Sri Lanka may or may not have done an adequate job, but shouldn't national states first be given the prerogative of investigating their own war crimes before, in the future, political bodies take this sort of quasi-investigative role?
Well, thanks for two questions which really would require more than a few minutes to respond. So let me give a telegraphic response to both. On the Rwanda situation, just by way of explanation, the issue is that there's credible evidence that emerged over the years that the army of Kagame, the present president of Rwanda, and the military genius who's put an end to the genocide, there's credible evidence that during the 1 year's jurisdiction of the Rwanda tribunal, that his army committed very serious war crimes involving many thousands of victims. And I can speak about it openly because this is an issue that didn't emerge during my watch, I'm happy to say, with some, and I'm relieved to say. But it arose during the watch of people who succeeded me as chief prosecutor of that tribunal. By any standards, the violations committed by the RPF army of Kagame should have been investigated. They fell within the jurisdiction of the court. The prosecutors didn't do it. And they didn't do it, there can be no question, because they were aware, and it was said publicly by the government of Rwanda, prosecutor, if you investigate crimes committed by our army, that's the end of our cooperation with you. We will break off all cooperation, and that would have been the end of the tribunal. The witnesses had to come from Rwanda. So a prosecutor is faced with a terrible choice. Do I do the honorable thing and prosecute across the board, or do I ignore these revenge attacks? Let me make that clear, that the attacks made by the RPF army were of a very different caliber to the genocide committed by the previous government of Rwanda. 800,000 people killed in a genocide over less than 100 days. These were revenge attacks by the army of the victims. The prosecutors, I believe, unfortunately, simply swept this under the rug. They didn't deal with it. They just didn't investigate. And the tribunal was able to continue to its conclusion. I think what I would have done, and I'm speaking with hindsight, and I don't say it in any criticism of them at all. I think they were in a very difficult position. What I think should have been said is our job, we were set up to investigate the genocide. 800,000 people. We weren't set up to investigate revenge attacks. We could investigate them, but I'm not going to jeopardize the major purpose of this tribunal, which is the genocide and the future of the people of Rwanda. I'm not going to jeopardize this by being holier than thou and going against people who didn't commit genocide. I think, incidentally, the Yugoslavia tribunal was faced with a similar decision when Russia complained about NATO crimes in the bombing of Kosovo. I think on a scale of 1 to 10, with 10 as the most serious, the Yugoslavia tribunal and the Rwanda tribunal were investigating genocides at 9s and 10s. I think the revenge attacks may have been at 4 and 5s and 6s. The NATO crimes were at 1s and 2s. They were negligence. So I think I would have advised a pragmatic solution, and I would have had to live with it.
And you'll have to answer parts 2 and 3 afterwards.
Okay.
But everybody, please, again, join me in thanking